Hello and good morning, everyone. Welcome to the monthly Startups in the Law series hosted by JonesKertz. We have Kyle Kertz here today, and he will be going in depth on best practices on starting and growing a venture and how the law affects startups. If you have any questions for Kyle today, feel free to leave them in the comments section. Friendly reminder that these sessions happen once a month, so if you find them helpful or if you think others might too, feel free to spread the word. So without further ado, I'll bring up Kyle and let him take it away from here.
Thank you, JC, for the introduction. Really appreciate it. As she said, we host this webinar once a month. This webinar, I should say, is for educational purposes. This is not a sales pitch. You may have seen some other lawyers do a bunch of sales pitches when they do webinars, and it really makes the viewers feel uncomfortable. This is more designed to give you information, more designed to give you the background knowledge that you would use to be able to start and grow a business the right way. So, we try to make this, more democratic, more accessible for the viewers so that they understand that, we're having a conversation, not necessarily trying to sell them anything. We absolutely love what we do. We work with tech startups all day long, every day. We work with larger tech companies that maybe aren't considered startups as well, but they do a lot of tech-driven business and do some really valuable transactions and things like that. I will say, our experience is based in deals. We consider ourselves deal lawyers. We are not going to be the type of lawyers that go to a courtroom. We are not going to be the type of lawyers to litigate issues all the way to a final conclusion. We are deal lawyers, and that's pretty much all I do every single day, every hour of every day. And same thing with me and my business partner. Matt Jones is based in Oklahoma City. I am based in Dallas, but I do most of the work, if not all of the work, for our Texas clients. And then Matt Jones who's the original partner here, has been around for about 8 or 9 years, and he is based in Oklahoma City, where he actually controls basically the entire region of Oklahoma from a tech startup standpoint for our law firm, as well as a lot of the customers and clients that need tech startup help in Oklahoma. He's sort of known as the guy there now. And so if you're based in Oklahoma, or if you have business deals in Oklahoma and you need help with him, feel free to reach out to him at mjones@vergelaw.com. His phone number, his email are right there. If you have a question for me about this webinar, anything that doesn't turn into an attorney-client relationship just on its face, shoot me an email, kyle@joneskertz.com. I try to be fairly responsive to the emails here. If we're covering something today that you are not necessarily interested in, or if we're not covering something today that you are interested in, feel free to drop a comment here. And let us know what your questions are so that we can address those. Okay. I'm going to be monitoring the comments throughout. I'm going to try to be catching these comments as they come about and answering them in the best way that I can. And then, just to explain a little bit more about the mission here. So I've said this once, I've said it a million times. This webinar is really about, better education, which leads to a better legal foundation for your business, which leads to more successful startups. You've probably heard the term that 9 out of 10 new businesses end up going on to fail. The reality is for our clients, the failure rate is a lot lower. And whether that be because the clients were already around and, they're no longer just, a going concern, they actually have, found their market, have solidified the product and their customer base, or because, we help them start up and advise them from the beginning. We tend to see that they're more successful because they tend to understand a little bit better when to reach out for help. And that's part of what I'm trying to teach all of the people who view this webinar. It's not a matter of, selling new business. I don't care who you use as a startup lawyer or a business lawyer. I just want you to understand when it makes sense for you to get to the point, to do your own deal up to the point of where you do need a lawyer, and then get them involved so that you reduce the expense, reduce the time it takes for them to get a deal done, and also just become a better business person. You ought to be, so educated in these subjects if you're running your own business that You understand the ins and outs of these deals. You understand what these terms mean. And you need to be more than conversational about some of this stuff. You need to not just look smart, but be very smart when it comes to, and knowledgeable when it comes to doing deals. Okay. And that's the mission here. All right. We want you to be more successful. We want you to create newfound generational wealth, and we want you to not just survive, but thrive, especially since the economy is about to get going again and really kick into high gear. And I'll talk about that here in a little bit more later. So, legal disclaimer, I have to do this because, insurance and other things, this is not legal advice for you or your business. Please don't act on this info without seeking advice from your attorney, whether that be us or whether that be someone else. There are no absolutes when practicing law. We frame everything based on the facts available and conduct research to reach legal conclusions. Remember, you are not a lawyer unless, of course, you are one, in which case I will give you the old saying that a lot of lawyers have told numerous clients, pretty much for the last 200 or 300 years. The person who serves as his own lawyer has a fool for a client. The reality is, if you are not totally educated in how to do these deals, I do not recommend that you run one on your own. If you understand contract law well enough to be able to draft a deal, I would say maybe do it. If you don't, make sure you rely on a third party. Get someone else involved at some point. It's worth the money, I will tell you, because some people who do this on a daily basis just know more than you do. That said, if you're not a lawyer, obviously go find one if you think you need one. Really, I can't advise you to draft your own contracts. I can't advise you to negotiate your own deals unless you are comfortable doing so. The reality, and when I say negotiate your own deals, that's only if you're comfortable doing so. When it comes to drafting contracts, don't try to do that. It's unauthorized practice of law in many cases, especially if you're, attempting, even representing yourself or representing your company. Your company is technically a third party in a transaction, and you could be violating some sort of fiduciary duty if you engage in a contract. If you draft your own contract, especially if your company is larger and has taken investment, recommend hiring outside help. So, without further ado, legal and startup news updates. We do this at the very beginning of every single webinar. We do this to make sure that we're sort of keeping up to date. But this time, I'm going to address two topics. Number one, taxes. It is tax day. Unfortunately, this is for a lot of people the least happy day of the year for them because, well, if people are rich, they technically hate paying the government or cutting a check. I personally know a few people who this is the worst day, and I never call them on a day like today. Though I know a bunch of people who they consider it a service to others, to be able to pay their taxes and things like that. Here's the deal. Unless you lived in Louisiana, Oklahoma, or Texas, you should have already filed your taxes or filed for an extension. If you have not done that, you need to reach out to your accountant and figure out what the heck to do. Unfortunately, we don't give a ton of tax advice, really none at all, I will tell you, aside from the stuff that is directly related to startup law that we can advise on and for sure understand ourselves without needing some sort of advanced degree or some sort of accounting degree to do so. But June 15th, today is the deadline. End of business today is the deadline. Highly recommend you get with your accountant if you have not done that yet. If you have a Texas LLC, if you have a Texas corporation, or if you have a Delaware corporation that's operating pretty much exclusively in the state of Texas, you probably need to figure that out right now. So second quarter estimated tax payments are due for the year 2021. I just got an email about that for our law firm because we have employees. We got to pay the estimated tax. It's not exactly the happiest moment for me, but at the same time, it is what it is. If you have employees, you got to pay tax. S corporations and partnerships who file for an extension should be ready to file by September 15th. For individuals and C corporations, if you filed an extension, October 15th. An extension only applies to the filing of a tax return, but does not delay when tax payments are due. In other words, when you file for an extension, you actually owe the estimated tax payment for that year, the amount at least that you have not paid yet, right? The estimated amount. So And that's about where I draw the line as far as advising people. I got this stuff from my accountant, actually, who sends a newsletter. My accountant is ioogo.com, if you're interested. They serve a lot of startups as well. Very good people. Highly recommend them. Also, reach out to them if you need to do something in a snap today. I'm sure they're very busy. I'm not sure if they're taking clients on a day like today, but the reality is, if you're not going to make the deadline today, you might as well just talk to someone. Okay. And I know a lot of people think they can do it themselves. That's okay. I would just recommend that, if you're making a certain amount of money, if you have certain types of income, don't do it yourself. Hire an accountant. It's just a lot easier. Take that stress off yourself. If you have any questions for me, like I said, you have any questions, talk to an accountant. This is something that I'm actually going to talk about at length today. So you probably heard in the news recently about a little thing called Delta-8 THC. As a matter of fact, there are businesses beginning to pop up that are billing themselves as dispensaries. And it appears to me that there is some sort of disagreement among lawyers and regulators and the people who are running businesses like the one you see here, Bloom Labs. And I'm not disparaging Bloom Labs at all, by the way. I actually kind of love the brand here. They came up with a trademark that actually looks really awesome. And, I think once marijuana goes fully legal, this brand will translate extremely well. They did a very good job creating the design of the trademark here. The one thing you ought to know, though, the question here is, is it legal? The reality is this is not marijuana based on the literature I was able to consume over the past 24 hours. This is really just an offshoot or a chemical derivative of another form of legal, hemp-derived product. And some of you who may know more about this are probably going to say he doesn't know what he's talking about. The reality is I am not 100% versed in all of this, but I do have enough information to be able to give you a legal opinion on it because I have done the research. Our team worked on this last week and worked on it on Monday. So without further ado, Delta-8 is a substance found in cannabis. It's what's known as an isomer of the better known Delta-9 THC, which is the major psychoactive constituent of marijuana. Recently passed regulatory changes contained in the 2018 Farm Bill have left some believing that Delta-8 THC is now legal to sell at the federal level. And I will get to that here in a minute because it's important to understand the differing opinions on the sides in the legal arguments for whether somebody could be right or could be wrong here. Okay. So that's basically it in a nutshell. Here's the chemical structure of it, though. So like it said before, Delta-8, same psychoactive effect as Delta-9. So effectively, it's the same exact product, though apparently there's a slight difference in potency. When I say slight, a major difference in potency. It's probably going to be, this is sort of, slipping and falling within the cracks of regulations and controlled substances laws. And I'll get to that again here in a minute. Apparently they're almost completely identical. I think the only real difference, if you can tell here, is this part of the structure right here, and then this part of the structure right here, which is slightly more. This angle is not as large as this angle is. I'm not a scientist. Don't call me on this. I'm not really concerned with the chemical structure of this. It's really more of the legal effect. So. As a result of this, businesses have begun selling the psychoactive Delta-8 THC as an alternative to standard marijuana in states where the latter is still not legal. And in Texas, we should all be aware that marijuana is still not legal. Okay, just because there has been quite a bit of deregulation in places like Austin and San Antonio and Dallas does not mean that this is completely deregulated to the point where you can just open up a shop and a storefront with it. That said, it appears that some people are interpreting it that way. and interpreting the law that way because they are reading it and thinking to themselves, yes, I can now do this. This is not prohibited. This makes a lot of sense. I mean, there are a lot of other risk factors here, which I will get to in a minute, that are not just risk factors related to the criminal liability that you should be concerned about if you begin selling something like this. So, and the truth is, there are a lot of news articles about this. You can go read on it. From what I can tell, the marijuana lobby, as well as anyone selling this stuff, has an opinion on this stuff, and they'll say that it's illegal 100%, which I would recommend to you. Don't trust it. Don't think that that's just going to be the case. Okay. And as a matter of fact, there are some other things that you should consider if you're opening a dispensary or something that sells this, and it's not yet fully standard legal under the statute, which I'll get to in a minute. So production, two main production methods. It's derivative from hemp, synthetically altering CBD through exposure to heat or acid. The second part is probably the way it's actually happening for a lot of these people that are selling it. The question also does become, where are they manufacturing it? Where are they developing it? What is the process, and what are the regulations for doing such a thing? Obviously, these are basically consumer grade products. In some cases, these things are being put into food, such as edibles. If you can tell here, this edible, I believe that's actually Lotus Gold, the brand, if you've ever been to states such as Oklahoma or other states such as Colorado. But the reason why we say here the method of production may be determinative of the resulting product's legality is because I actually read an opinion that said that because of the way this is produced and the isomer that is produced as a result of this chemical change that and this process that the CBD undergoes, apparently the process itself makes it so that you cannot determine whether or not it was derived from some other form of THC product or just regular marijuana, or whether it was derived from CBD. They're sort of backing themselves into this chemical compound that really does exist naturally in marijuana, but it does not exist naturally in the CBD that is produced from the hemp plants. And so the problem with that ultimately becomes, let's say, for example, you get arrested with something like this. You're in possession of edibles. You're in possession of something that might say on its face that it's not actually in violation of the law. But the reality is the police really do not have to trust that from a legal standpoint. They can still confiscate the goods. They can still take it off your hands. They can still arrest you and potentially even charge you pending the results of, a test of the product itself. And that's another thing. This is kind of a slippery slope here. Okay. Like, whenever you set up a dispensary like this and you begin growing the product in plain view, as Bloom Labs is doing in the previous slide, as well as, selling all of this stuff, you sort of put yourself under greater scrutiny, especially if the law is sort of in a gray area. You don't necessarily want to open yourself up to that because you really just are liable to having your business shut down, number one. You're liable to having all of your staff members arrested because technically, by virtue of the fact that they are working in the facility, they are technically co-conspirators in the commission of a crime, which could be considered a felony. There's no way you can actually protect them. There's no insurance you can buy that will protect you from getting arrested for this sort of thing, unless, of course, somebody has come up with an insurance product for that, which I doubt they have because it would be in violation of law. The Texas Department of Insurance would never allow such a thing. And so when you look at this, you're looking at a situation where you have to self-insure everything. You basically have to treat everything as under armed guard. Let's say, for example, that you actually have to put it under armed guard if this stuff is technically illegal and you have weapons in plain view, or you have weapons in your possession and you are in possession of a product that could technically be considered illegal, technically it's illegal to own the gun. You're now not just looking at, 2 to 5 years, you're looking at 5 to 10 in state prison and federal prison, potentially. And so, when you're assessing the risks here, maybe, just maybe, it's not worth it. The other risk here that I want to talk about is commercial real estate. So let's go back to Bloom Labs. Bloom Labs, for those of you who live in Dallas, you'll know that the part of town that's called Deep Ellum. For those of you who do not live in Dallas, Deep Ellum is lowest Elm Street here in Dallas. It's pretty close to downtown. It's basically walking distance from a lot of major hotels and businesses there. It is a major bar and restaurant district, but it is also a major retail district. And it is probably the only place that you will go in Dallas, that is north of downtown, where you will be able to smell marijuana just smoked freely in plain view of police and everything like that. The police won't even arrest people on a Friday and Saturday night if they're smoking it in plain view. This place opened up in Deep Ellum. It's probably the best place for it because they're least likely to actually get arrested or shut down for doing this there. But at the same time, in my opinion, when you do something like this, you completely eliminate the ability. Well, when you're doing it in plain view, technically the police have, and it's questionable as to whether or not the law is actually, or to whether or not this is legal or not. Technically, the police can conjure up any sort of probable cause just by looking through the window or something like that. They could potentially, or just by entering the premises because they see other people entering it, they could go in and take a look at everything, inspect it, potentially even confiscate and raid it because they think it's illegal. I don't know if Dallas is actually going to do that because Dallas has Dallas is Democratic run as a city and county. It's also pretty hands-off when it comes to low-level drug offenses. And what I think may be happening here, which is actually important to note because it will affect how this comes about at the state level. If the laws do not change from a federal perspective or a state perspective legalizing this sort of thing, then at that point, it's going to become a court issue where somebody ends up getting accused of violating the law and then says, no, I wasn't. Technically, the law allows it. And at that point, they're going to escalate it either in federal or state court and try to get a determination that the law itself actually did allow this and that they were unjustly prosecuted for a crime they never committed. That's basically the legal argument. So technically, the Schedule of Controlled Substances includes all forms of THC, except for THC found in hemp. That said, there's a threshold 0.3% on a dry weight basis. If you don't know what that is, I would ask a friend or ask somebody who works in laboratories who can tell you exactly and precisely what this actually means. Because I don't have time to go into it, though I do know what it means. The only potentially legal production method for Delta HCAC is deriving it from cannabis plants that are compliant with the statutory definition of hemp, meaning you would basically have to track the testing of the hemp plant, ensure that it had just the right amount of THC in it so that it wasn't illegal. If it was illegal, they have to discard it or throw it away in compliance with Texas regulations. And then once it is processed, they have to double insure. They have to make sure that they also ensure that it is tested properly to ensure it's not in violation of the law. It doesn't have more than the required amount of THC or the threshold of THC. The reality, though, is do people do this every single time? It's relatively expensive to get the testing done if you don't have the capability of doing it yourself. It does drive the cost of the product up. That said, there are plenty of third parties that are popping up who are doing it. I predict that the cost of doing so will go down, actually, especially as marijuana is legalized more and more, as well as the production of hemp actually increases because it was legalized 2 or 3 years ago. And so the reality is, I I mean, really, you're going to have really a slip of paper. It would be useful to have that from a third party or someone else that can verify that this has been tested. It has been tested to within regulation, and it has been tested in accordance, and it is legally compliant. I mean, having the certificates, having a statement, having a signed, whatever you want to call it, it's probably not considered an affidavit because technically it's not legally binding in court unless Texas regulations provide for such a thing, which I believe they actually do have a way in which you can test this and certify that it is actually indeed compliant. And so that's the key to doing all of this. You have to certify all of that for sure. The only problem is the method of production is probably on its face illegal from a federal law standpoint, is what I would say. Plants that are hemp are not included in the definition of marijuana anymore. That's because the federal law actually preempted state law with respect to that rule. However, Texas Penalty Group 2 outlaws all forms of THC with no exceptions for those derived from hemp. And that's where the illegality comes from. Again, illegal at the federal level, illegal at the state level, potentially. Actually, in this case, is named in the law as an example of a prohibited substance. And so we have a very clear instance in which the business itself is operating this business right here. If they are getting legal advice, they are getting wrong legal advice, or they are getting legal advice from a lawyer who's intentionally helping them break the law. And that is a violation of a lawyer's duty, to ensure that they are not breaking any laws when they are providing advice to their clients. What I probably expect happened was that this company hired one or more consultants for people that wanted to do this. In my opinion, they've jumped the gun. They probably did get research from an attorney, and that attorney may have given an opinion which said that federal law, because of its preemptive nature, preempts the law under state Texas, which prohibits the Delta 6 THC / Delta 8 THC molecular structure prohibition. And so the conclusion here is Delta 8 THC is likely illegal in Texas, regardless of the source. Selling such products in the state of Texas creates not just the risk of criminal conviction, but the likelihood of it if you get arrested for it. And that's the major issue. You have to sit there and think, do I want to be the person who forces this law? Does it have to be state versus Bloom Labs in order for someone in order for this law to get overturned because it would be considered federally preempted. The reality is you don't want to be here 3 years from now figuring that out. The other thing you should probably be concerned about for anybody that starts a business like Bloom Labs, remember that if you have children and you get arrested or doing something illegal like this, you technically do not have to be arrested for doing something like this to be considered a danger to your child, to the point where you can have your children removed from you. And that is probably one of the things that you need to understand most. This is not the risk that somebody who has children should probably take, unless, of course, those children have already been taken away from you, in which case, at that point, it's a matter of whether you care about getting your kids back. Because I guarantee you, any lawyer who's reading the law that I'm reading, interpreting it the way that I'm interpreting it, is going to sit there and argue in court that this person is operating an illegal cannabis business. It's in clear violation of the law. That person is now a danger to the child because they are at risk of getting arrested at any time, right? And that's a great argument if you're trying to get somebody, if you're trying to prevent somebody from being able to get their kids back. It's not a great argument, I should say. The way I would say is it's a legal argument that wins, not the legal argument that loses. The reality is, I would say, and last but not least, this is the last slide for this topic. There are currently no existing scientific tests for the origin of Delta 8 THC. When it comes to this, you absolutely do need to take into account the fact that you're going to have to track every bit of the testing of this. And I don't want to say go the distance and actually record yourself manufacturing this stuff, because obviously anything like that could be used against you in a court of law. Recording yourself committing a crime is definitely not something any criminal lawyer would advise you to do. But that said, the government would be unable to prove whether the delta 8 THC molecules being sold were illegally synthesized from CBD, and they would be unable to prove whether or not they came from just regular marijuana plants. That said, if you're sitting there thinking about this, you're saying, however, if the burden of proof is placed on the defendant, in this case being the person who is arrested for, possessing this stuff, arrested for selling it, arrested for manufacturing it or transporting it, it is potentially going to be on you to prove that the delta 8 THC was legally derived from hemp and accepted from the schedule of controlled substances. I mean, you'll probably be unable to do that as well, unless, of course, you have some sort of document and some sort of eyewitness who can testify to such a fact, right? And I have a question here. Is it really innocent until proven guilty in that situation? The reality is, when you're arrested for a crime such as this, I mean, let's say, for example, that, when you get arrested for a crime such as this, and it's very clear that the statute prohibits it, technically, in the state of Texas, the issue is now not how it was manufactured. The issue is whether it is actually delta 8 THC. So effectively, they basically do the chemical analysis. I mean, put this stuff in a centrifuge and determine what the heck it actually is. And then at that point, prove whether or not it was actually, the substance that violated the law. People are considering this a loophole. In Texas, it's not a loophole. We very clearly showed you that there is a statute that says that delta 8 THC is technically a derivative compound that is illegal under Texas law. So Bloom Labs, I'm sorry about you. We're not specifically trying to call you out, but you are the one advertising on Dallas, Texas TV's Instagram a ton. So basically, it's on you. You're just openly violating the law. Should have gotten better legal advice. I'm actually curious as to who your lawyers are. The legislature, by the way, could at any time enact, regulatory changes to, fix or amend the existing loophole to make it clearer that such a thing is actually indeed illegal. I have here a comment about the legality of this, though. So let's say, for example, that there are two ways I interpret law, right? There's the way that's I can sit here and do the conservative approach, right? And the conservative approach says, if the law says I can do this, or the law specifically says it prohibits this, then technically that's what it says. It does not allow you to do anything more than that. That's one way of viewing it. The opposite way of viewing it is, if the law doesn't say I can do something, then technically I'm allowed to do it. I mean, the instance would be, let's say, for example, that, I remember there was some regulation of K2, years and years back, right? This was probably like 10 years ago or so. The substance K2 was, obviously targeting a certain demographic, and, was basically being combined with other drugs and substances, which was giving people some sort of maniacally high effect, and they ended up regulating it. Sometimes, indeed, controlled substances that were previously not controlled have to be regulated to be controlled. I think K2 was actually an instance of that. The problem is, it appears here that they are actually controlling this substance with a regulation. So I think we're looking at a situation where, this is not, it's actually very clear here. I mean, the only thing that's not clear is some people here seem to be interpreting a statute for what they want it to conclude, as opposed to what they actually know it says, right? I mean, people will construe facts to reach their conclusion as much as they want, but you can't argue with the fact that like it is specifically called out as prohibited. You can't use a derivative to create you can't use a derivative of a product to create a derivative of that derivative, because technically the process in which you're creating it is technically illegal on its face. You can't use delta 6 to create delta 8 in a way, because delta 6 on its face is illegal, therefore delta 8 is illegal. I mean, that's like saying, the comparison could be, cocaine can technically be processed into a substance that's known on the street as freebase. Like you can't claim that because it's not cocaine anymore that it's not illegal. The derivative itself was already illegal, right? Like the product further up the chain was technically illegal. The derivative product of it is technically illegal as well. So does anyone have any questions about that? I mean, obviously, I will say, we're not totally cannabis lawyers, though we do some cannabis law in the state of Oklahoma. And, we help people buy, sell cannabis businesses, purchase and invest in cannabis businesses, and also, manufacture and sell that product. I will tell you, it's an interesting industry, and I believe there's a lot more. There's so much money in this industry. It's such a shame that Texas hasn't legalized marijuana in some fashion that would allow people to consume it recreationally or just legally on its face. Because in reality, if you bring it off the black market and onto the white market, you are going to effectively, produce billions and billions in taxable income. It really is something that we should be taxing. I mean, there's a whole lot of good that could be done with the tax money from this sort of thing. That said, I don't have a lot of faith in a regulatory regime for the state of Texas. The state of Texas has effectively created an oligopoly for whatever legal marijuana does exist in the state of Texas, which, by the way, there is a law that actually legalizes compassionate use of marijuana, which I addressed in a previous webinar that you can go find on Capital Factory's YouTube page. But that is what I want to say. I would say for now, don't open a shop like this. You're just putting yourself at risk, potentially putting your family at risk, putting your livelihood at risk. If the stuff that you are selling can be confiscated at any time, then technically you do not have a viable business, in my opinion. That's just a fact. If we don't have any questions, I'm going to move on to the next part of this series. So I'm going to get some coffee before I do this. Hold on. So, Series A transactions. I've addressed investment transactions previously, and I did, basically almost a 3-part series over the last few months where I talked about the anatomy of these transactions. I talked about, accredited investor requirements, transaction types, different investment vehicles. I talked about entity structures for these investments. I talked about, fundraising. I mean, some advice about what to do, when to do it, things like that when it comes to securities laws. I'm still going to talk a little bit about that today, but I want to talk about Series A today only because we've been doing, more Series A transactions lately. And it's getting to the point where, we want to educate the general public on what to know about this generally. I say there are no absolutes in law, but in this, there are some pretty standard stuff. There's some pretty standard stuff. And we experienced some pushback from, some of the people selling, the investment stakes in their businesses, very good businesses, very good CEOs, but stuff I wanted to address because I found it, a little bit odd. I found it a little bit strange that I was getting pushback on these things. And I also want to talk about some cultural differences when you might be doing cross-border transactions or transactions with people who are coming from different countries. So without further ado, by the way, if you have any Series A or any fundraising questions, please feel free to throw them down in the comments. I would love to hear them. I would love to answer them. Okay. So going forward though, there are a lot of reports, by the way. I'm going to give some data here, but I want to put this caveat out there. Every single time I go to find venture capital data, all the data is different. I don't know why the industry cannot agree on the numbers here. But there needs to be some sort of convention that we need to convene and figure out how to actually crunch this data as a community. Like if you're doing venture capital transactions, we need to understand, where are we sourcing this information? Where are we getting it all? And how are we compiling it so that the data is accurate? I could not find, data that told me the same thing or roughly the same thing in any two places on the internet for the year 2020. Every single bit of data, all the trends data that I saw was completely different. And we're talking standard deviations of between 2 and 5 million in certain places, which meant that the data was not good. Some of the data was not good. Some of the data might have been accurate or might have just been, deeply flawed in some cases. That said, I think the data that I found was better because it was slightly a little bit older. And I did take data from two different sources here. One was from this Wing Venture Capital report. Another one was from Cooley Go, which Cooley is a large startup law firm. And, we don't tend to compare ourselves to them because they are a much larger national and international law firm. And they do way larger transactions, way higher stakes transactions. I'll tell you, so the median amount of money raised leading up to Series A was 3.3 million, in 2020, and then, up from 3 million in 2018 and 5.5. And it was like the 2020 number was 5.5 times the $600,000 median of 2010. So basically, if you're interpreting data for what it should mean, we can reach a ton of conclusions, but what this really means to me is that venture capital is becoming a friendlier place to invest money. People are looking to it as a more standard method of investment because the transaction amounts are going higher and higher. We can factor inflation into this, right, and see that, hey, maybe the trend, if we adjust for inflation, technically these numbers actually are closer than they might appear. But if we take a look at this, just in total dollar size from a transaction amount for the entire round, it really is growing. People are getting far more comfortable with the amount of money they're spending on this. And it tells me that they're getting far more comfortable with the format of the deals, and they probably figured out what makes a deal worthwhile for them to the point that they will invest, low to mid or even high seven figures in a company like that, in a company like tech startups. So seed financing doubled from 2016 to 2020. I have data here. This $2.2 million number came from Cooley because I didn't have the Wing Venture Capital report did not have a 2020 number. Though I think this number is actually inaccurate. The 2020 number, I believe it's probably higher and closer to 4 or 5 million. Because the reality is there were more venture capital deals done last year than any other year on record. And if we're sitting there understanding that, if this number is right, then what it's telling me is that the transaction amounts went down, but the number of transactions went up, right? Which might make sense. Also, what this suggests is that the valuations were lower because of the pandemic during 2020, which would also make a lot of sense. That said, I don't know that for sure because the data is just so off the charts wild. I can't tell. That said, if you look at the numbers here, you can tell this is the seed financing leading up to Series A is growing like crazy. People are getting way more confident earlier on. That said, valuations pretty high, I'll tell you, for seed financing, though, $11 million up from 9.4. That's all in 2018. Pre-revenue seed rounds becoming exceedingly scarce. This is something that I've been saying about Texas and something that you need to understand if you're going to raise money for your business. very few people want to invest in a business that doesn't earn revenue. When a business earns revenue, when a business can monetize whatever product or service it's created, especially a mobile app, for example, or a website, for example, that shows a couple of things. Number one, product market fit. I mean, you've found a customer to buy something. I mean, in some cases, those customers might be experimenting, but if you can prove retention, if you can show low enough customer acquisition cost, or at least show that you can reduce that CAC over time, then you've potentially got more argument for yourself, right? The problem with a pre-revenue business is it's always these businesses are struggling so hard with getting investment, and we do have a lot of pre-revenue startups. Pre-revenue startups are hard to do. I mean, they take a lot of time to get off the ground. That said, a lot of pre-revenue startups do have valuations like $11 million. We just did a deal the other day where the valuation was like 8.5. And the reality is, that was sort of arbitrary. We did a safe, and that was what was negotiated, the valuation cap. As far as that deal is concerned, people are that one client that we have that is getting early money, they just produced their beta. So what makes sense, if you're not pre-revenue, what makes people feel more confident about it is their beta, went live on the App Store, on the Apple App Store, went live on the Android App Store as well. And so finally, they received, an additional $50,000 in investment the other week. It was hard to get there, though. The problem is these people don't want. There are some people who just don't want to purchase at a price like that, or they don't want to purchase that early on. The institutional investors just don't understand it, or the institutional investors do understand it, I should say. But the problem is most of the institutional investors, if they're venture principals or if they're partners, when they go to their weekly meetings, when they go to their investment meetings where they're talking about potential customers to invest in the due diligence process, or potential portfolio businesses to invest and do further due diligence and actually allocate money to them, it can be a very hard pitch to invest in something that's pre-revenue. And even then, most of the VC funds that are doing this will sit there and tell you, no, we don't want to do this. Well, our criteria is pretty, set in stone on the fact that they can't invest in pre-revenue businesses. A lot of people will actually tell you that. You're too early for us. We'd like to talk to you when you're ready to do a true seed, or when you're ready to do a Series C or Series A. But yeah, 2/3 of companies closing seed financing generated revenue at the time, up from only 9% in 2010. So goes to show you that either, the seed rounds the seed rounds today are what the Series A's used to be yesterday, 10 years ago, or people are just getting, or people have figured out that, they're able to hedge the risk way better that the company will fail, or at least hedge the risk that the company will fail to grow quickly enough for the investment to actually make sense by investing in a company that is actually generating revenue. Median Series A stats, 2019, 12.4, 2018, 11.9, 2010, 5.1, double pretty much, right? That's pretty big. Median pre-money valuation stats, 30 million, 28.5. Okay. And so you can see it's growing, but it's probably sort of plateauing there from a valuation standpoint. We don't have the means, unfortunately, on this, the averages, because I wasn't able to find solid enough averages for me to see this. And by the way, all of the data I've ever been able to see usually is median, not average. 77% of Series A companies in 2019 were revenue generating. 2016 was 75%. So yet again, level basically. They're hovering right around 3/4. Up significantly since 2010, 7.7%. Which means, like the people are getting, what this tells me is that most of the Series A's are really risk averse. It probably also suggests that, we can say it as much as we want to speculate. When I look at this, though, a lot of times I think, we're getting away from true innovation in some cases. There are very few companies that are doing something extremely different. We have two companies that I'm aware of, we have two companies that are our clients that were doing something where it had really never been done before. There wasn't a similar product on the market, and they knew it for sure. And that was true. I mean, we worked with them extensively over the last year and a half. And I can tell you that those two companies were literally like, the moment it came out, it was either going to be a hit or it was going to be something so different that some people were going to go, what the heck is that? Right? Just extremely innovative ideas that get used by people that are, really, well, what I'll say is, what this tells me is that the venture partners, the venture capital firms are getting away from riskier investments, which might have, a higher earning potential. They're really looking more for the sure thing, which I believe is true for a lot of people. They've got limited partners, they've got fiduciary duties, they don't want to violate, things like that. So Series A process, due diligence. I just want to say generally, like when it comes to Series A's, we're sort of doing the diligence process around the same time we're doing term sheet as well. We really have to do it that way because, we have to understand the structure of the business. We have to understand how many owners there are. We have to understand the shareholder makeup and the percentage of ownership, and basically the fully diluted cap table, as it's known, before we go and write the term sheet, because we have to do the calculations to figure out how many shares are going to be issued up to this amount, how much, what the purchase price is. I mean, we need to understand valuations. We need to understand if they've complied with valuation regulations, such as 409A valuations. We need to look at major contracts to ensure that, hey, these guys aren't committing fraud. They're not telling us, that they have contracts, but they really don't. They're not telling us that they did really good deals, but they really didn't. We have to look at financial statements. We have to look at employee agreements. We have to look at the, founders agreements, the restricted stock purchase agreements, bylaws, everything. If there's anything that was ever done in the past, it has to be looked at, has to be in the system. People talk about a data room. It's very helpful that when the parties go into this process, that they just throw everybody into a data room and do the deal. And look at it together, discuss it together. There's a lot of discussion that goes into it, and you really should take your time on that. I mean, do it quickly, but make sure you're reading it. Make sure you understand whether these people are subject to non-competes in their employment agreements, because it's pretty important for the people creating extremely innovative tech businesses. Make sure that the certificate of incorporation either doesn't need to be amended, or if it does, what needs to be changed about it, right? And then, make sure that the shares are actually calculated properly when you produce a cap table for this. This is not an exclusive list of what goes into a due diligence process. This is just something that, this is just a finite, short bullet point of what the most important parts really are. I've got to be able to see your org docs. I've got to be able to see your structure. I've got to be able to see who owns what. I've got to be able to see if the documents, especially for this cap table, if the documents that in previous investors used actually were the numbers are actually line up, so that we're not in error, issuing the wrong amount of shares in this investment transaction, or converting people from safes or convertible notes into a new transaction. That's not the type of transaction we need. Or converting people into this new transaction, converting people along with this new transaction that is a calculation of shares that's actually wrong because we didn't read those documents beforehand. And that last part actually came up in discussions this past week. I was doing a deal where I basically wrote the entire deal for the client. I had most of the documents, didn't have all of them. I kept asking for the other documents, and I told the client, hey, I'm done drafting the deal. Basically, I just need to see, I just need to see the corporate documents, including, the certificate of incorporation. I need to see the stock purchase agreements, convertible notes, because there were some. I need to see any other contracts that they might have. I also need balance sheet, and I need P&L, because I need to see if they're making any money, and I need to see what the burn rate is. I also need to see what their assets are valued at, sort of on the balance sheet. So when it came down to it, we asked the person for that information. The person gave us some of the information, but didn't give us all of it. And that was a problem, because I'm sitting here going, you should have it. If you have convertible notes, those are securities. You got to have those. I mean, if I'm asking for them and you can't produce them, then the question is, do they exist, or did you just create this cap table? And you're, I don't want to say lying about it, but I mean, not being honest about the status of that equity, because I had to see if it had already converted or not, or if he was suggesting that this is what it would convert into, because he had given us the share calculations. And the other thing there is just ensure that, like I was trying to ensure that the structure of the company was being honored throughout these agreements, and that he wasn't using his title wrongly. There weren't any other additional liability issues. There wasn't any, outstanding accusations of fraud or anything like that, right? Or anything that could be a hazard to us if we acquired, a large minority or majority stake in the company. We were about to acquire a majority stake and take it over, basically. The reality is the format of that deal has now changed, and we are not doing that because the documents were not correct, and I just didn't feel comfortable with the risk there. And that does happen when you get first-time entrepreneurs who are maybe not using a lawyer for these documents, or using stuff that someone has given them, or pulling stuff offline because it's a cheaper cost of doing the same thing. The reality is, like I said, the person who serves as his own lawyer has a fool for a friend. You don't want to be doing that yourself, because you are potentially going to create some other problem for yourself. That person, the deal is not over. We're actually still doing the deal. It's just different structure. But it was a lot of work, and the client spent a lot of money. And that's the lesson I would give y'all. If you're going to do the deal, make sure you've done all the due diligence you need for the deal before you go and actually talk to your lawyer and have them draft up the documents. Better yet, ask your lawyer before he drafts the documents, can you send me a request list for due diligence so that I can send it out to this person? And that would be the appropriate way to start off that conversation. That way that person can check the box themselves, review the documents and see what's not there, and then tell the lawyer what's not there, right? Term sheet. So, once the due diligence process is done, or mostly done, make sure the term sheet is how you want it, right? Major points, pre-money, post-money valuation, which goes into the pre-closing, post-closing cap table. Also goes into any sort of stuff related to, it also goes into any sort of stuff related to, valuation cap if we're doing a convertible note or safe, right? We're going to be using the pre-money or the post-money valuation to calculate such a thing, typically. But we want to know the post-closing cap table structure. We want to know if this is an equity agreement, how many shares we're going to own, what the predicted, percentages will be at the end. Equity incentive plan structure, pre and post close. That's important. And I want to say why. We're in the process of finishing a transaction this week that's set to close on Friday or Thursday. This is a rare instance in which the deal was done so that the employee option pool is issued after the investment is done, which is not what I would have preferred. As a matter of fact, I was really saying that, hey, pre-closing, the pre-closing option pool needs to be 10%. It doesn't need to be post-closing option pool. They changed it to post-closing. The client said they were fine with that. I advised the client against it. The client said they wanted to do it anyway. That said, everything, as a lot of people should be aware, is the client's decision. I advise, I educate, and I ask them what they want to do. In the event they want to do something different, that's on them, so long as I had given them, so long as I'd given them the facts and laid it out for them, which I did. The reality, though, is, the good news is when you're taking a board seat as an investor and you do a post-closing option pool like that, I mean, the effect of it is, in my opinion, the effect of it is, somewhat negligible in reality. I mean, like it's not the end of the world. And also because they have a board seat and they have the ability to, further control the company. When you're looking at taking a board seat and doing something like that, well, there's mitigation that you can take there. They can potentially block a decision by the board or a decision by the company to issue shares to somebody, which would further dilute them. That said, we know what the employee option pool would do in terms of dilution. So, because it's already fully diluted on the cap table as a result of the transaction that we're doing, because it's going to be fully diluted on the cap table as a result of the transaction we're doing post closing. So, it's not the biggest deal in the world, and also the consideration in that respect, the exception. That person already owned 5 or 6% of the company and was buying an additional 5%. So if you're looking at, hey, this person's going to own 10% of the company. Well, at the end of the day, they're sitting there saying, it's fine, no big deal. And they ran the models themselves and said, we're still going to make money on it. Yeah, for sure. And part of these things is you have to ask yourself at some point, is it worth it more to do the deal because investing in great companies is the thing to do, or is it, like we don't want to ever do a bad deal. I mean, the reality is every deal is different, right? I mean, these terms are not an exclusive list. Well, price per share, obviously, if you're buying stock, you want that to be on there. The transaction type obviously has to go into there. You do need to say whether the equity incentive plan structure is pre or post close, because that's specific. That was the only exception in my experience where it was post-close and not pre-close. You don't really want to do it post-close, and I probably won't ever do that again because it's just it was a weird scenario where the person requested it to be so, and I saw that the CEO was going to undergo a massive amount of dilution, and part of the investment you have to consider the CEO. If that person once a transaction takes place is going to own so little of the company that they basically never want to work for the business because they're like, well, I own only 5% of this thing now. You have to consider their interest as well. So consider either doing the post close or actually better yet pre-close, equity incentive plan, and then use the equity incentive plan to issue options to the founder or the founders to keep them further motivated to stay with the company. Right of first refusals. Do a right of first refusal. Well, like there was a vehement opinion in a previous transaction where this person said that the right of first refusal was almost never included when it came to preferred stock, and that's not been our experience. I will tell you, typically especially if we're the largest one-time investment to date, we tend to get that right of first refusal. So I had actually, a problem with their point on that because I thought it was wrong. But at the same time, they made the point that certain venture capital firms don't do it. And I said, whatever, when it comes to this, we're not going to let, a term like this break the deal. We'll fix it with other protected terms, things like that. So you can move to restrictions on business activity, decision-making by management. Make sure that they're reined in enough to where they're not going to be just spending money with reckless abandon. And then, preemptive and anti-dilution rights. Now, this last part, I want to talk about anti-dilution. When it comes to, preferred stock with a Series A transaction, a lot of times I've heard other lawyers who will say almost always the Series A preferred stockholder, at least the largest Series A stockholder will receive anti-dilution. Now, That's not always the case. Like I said, no absolutes when it comes to practicing law, and every deal is different. That said, you have to consider what happens when you grant anti-dilution to somebody. So you can talk about, full ratchet versus weighted average, anti-dilution. You can talk about, all the different types of it. What I would say though is, consider the following. If you have not granted anti-dilution to anyone in the past, and your investment is or you're about to get investment in 7 figures, and the person is asking for anti-dilution, consider saying no for the reason that whenever you grant anti-dilution to somebody in a Series A, the next time you do a Series B, or Series A2 or Series A3 or something like that, or Series C, every single time these people are going to ask for anti-dilution, and that's going to be a sticking point going forward. You need to ask yourself: do I want to give everybody from this point on anti-dilution? Because that will be their argument. They'll sit there and say, "We're not investing unless you give it to us," and that's a strong argument. These other people are getting it. We're investing way more than those other people, or 5 times the previous amount. You should be giving us anti-dilution. It's a fair argument. But the better argument, in my opinion, is we've never given it before. And to be honest with you, I'm not of the opinion that I should ever give anti-dilution, because if you want equity in this company, you have to pay for it. That is a fantastic argument, I will tell you. It's also, it's also basically somebody saying in a very polite, legal manner, put your money where your mouth is. If you want more equity in this company, then re-up. Okay. We'll give you the right of first refusal, or give you a right of first offer, so that you have the ability to go through and do that. And we'll give you a chance to invest later on at a certain price, and match that price with the future Series A, Series B, Series C, and what have you. The other thing here I'll tell you is, other major rights, and we could go on and on, but registration rights are one that comes to mind. You do want the ability to, what happens if they register a public offering, or register for a public offering, register a draft registration statement? Are your shares going to be included? Are you going to have certain rights that are, superior to other people's rights? Or, are you going to have, I guess the right, are you going to want to sell out, in a certain way? And then, liquidation preference is key. If there's already been preferred stock that have been issued in the past, and at that point, the issue then becomes, then at that point, then the issue then becomes, then how are we stacking the liquidation preferences for preferred shares? Is this large investor getting superior liquidation preference to the previous preferred stockholders, or are they getting similar or the same liquidation preference rights? And by liquidation preference, I mean in the event the company is wound up and terminated, and they just make a distribution of assets, preferred stockholders get paid first. It just depends on what the certificate of incorporation says, what the stockholders agreement says, and any other documents that stipulate what happens when that event takes place. So, draft the transaction documents is the next step. Obviously, this is often where things get more difficult, because a term sheet is just a summary of terms. It is not a full-blown list of everything that goes into these documents. And we can't make it everything that goes into a stockholders agreement. We wouldn't want to. It just needs to be major points. But you go over things not covered by the term sheet must be addressed during this phase. Make sure you're honoring the language of the term sheet for everything that's covered. Be reasonable, but be firm on the things you want and need out of the transaction. And when I say be firm, yes, just tell them this is what we need, this is what we want. It's not a hey ultimatum, either this or we're going to walk, unless it really is a serious issue. At which point I don't give them an ultimatum, work with them, tell them, hey, this is really important. This is really, from a criteria standpoint, I've got to have this in order to get a deal closed. I've got to have this to get the partners of the venture capital firm to agree to this sort of thing. It's about making the deal come to life. And it's cheesy to say, but be a deal maker, not a deal breaker. Facilitate, be a facilitator. Don't be an obstacle. Don't be the person who is consistently making everyone in the room really angry about how you're conducting yourself. Okay. Let the people who know how to do this do it as well. Or if you are doing it yourself, make sure you're getting the advice and guidance that you need in order to be able to effectively negotiate this. Execution and post-closing. Make sure all documents are executed properly. Sometimes your lawyer may give you the documents to execute on your own. I highly recommend that you get your lawyer to use their DocuSign, get your lawyer to use their HelloSign or whatever other signature account that they're using. Ensure that the company does its securities filings, Reg D, other types of filings if necessary, post-close. Ensure the cap table is finalized and a stock ledger is given to all stockholders, okay? Make sure that the resolutions and all the transaction documents, a copy of which are all given to all stockholders. Ensure the new 409A valuation is done since the company has a new post-money valuation and has undergone a material event requiring new 409A valuation. And this last part is key. When you do a fundraising round, you need to set a new value for the company, basically. Unfortunately, when you do a new 409A, it could cost you a little bit of money. That said, it's worth it because you're going to need it, and it lasts for a year or until another material event takes place. That said, if your revenue is gaining, is growing really rapidly, if you're gathering assets really rapidly, and the value of those assets is growing, then at that point you need to consider, doing a 409A valuation prior to every new issuance of stock. It's just, something that needs to be done in the event you're growing super rapidly. We potentially ran into that with one of our clients who is growing, 100% year over year as from a revenue standpoint. And I had to suggest to them, hey, potentially we need a new 409A done because the previous one that was done 12 months ago, it's going to be outdated a little bit potentially. That said, the 409A is what's considered a safe harbor. If you get one done, then technically you fall within the safe harbor of having done what you need to do in order to fulfill securities laws and ensure that you're not committing fraud when it comes to pricing the stock that you're selling in your company. And that's really most key, prior to the issuance of options, prior to the issuance of other things. For earlier stage companies, we tend to see them play a little looser with the transaction documents, only because they are, their value is hard to determine in many cases because they don't have revenue. That said, if you are taking investment every now and then, get on Carta or get on another cap table software that allows you to put the numbers in there, plug your expenses in and revenue, even if you have zero revenue, and because Carta will do a 409A valuation for you. Because you need one done every single year as part of the service. And, really key to having that done on a regular basis. Because, when you are talking to sophisticated parties, when they ask for it, you want to be able to produce it. You want to be able to get to them. Or you want to be able to say, we're doing a new one right now. We'll let you know on the price. We're just talking about substance of the agreement. Price per share is, something we'll determine later, right? Here's a question that I think is, somewhat common in these documents. Okay, there are errors that are going to be made. There are potentially errors that can be made in these documents. There's a lot of things going on in these documents, and potentially some conflicts between the documents themselves. And I'll talk about that in a minute. What happens if one of the documents contains an error? Fix it if you discover it early enough. Okay, it's really better to catch something early on. If you just executed everything, yes, it is a pain to re-execute everything. But in some cases, you can sit there and say, okay, these documents only have to be amended by certain parties, and consent really needs to only be obtained from these other parties. In that case, go do that. there is a clause that you can actually include in certain contracts, okay? And, lawyers don't actually do this a ton, but we're going to start doing this a lot more for our deals. And basically, it's going to be a scrivener's error clause. So basically, let's say, for example, that I write in, the value of a train, or that I write in, a term, right? And for whatever reason, I misspelled it. For whatever reason, I flubbed, a party's name, which, unfortunately, lawyers are human beings too. We're potentially imperfect. Though everybody wants us to be perfect, we always have to be on point to our clients. It does happen. We usually catch those things, and I have people review the documents before they go out. But if it does happen for whatever reason, then a scrivener's error clause can say something to the effect of, in the event that a scrivener's error is determined to have been made and it does not affect one or more of these other terms, such as financial terms or anything like that, then technically a unilateral amendment can be made to fix the clerical error, basically just the input of a party's name, the input of a comma between a company name and the word Inc. or something like that. Something that is not necessarily super huge or going to alter the rights of the parties. That's what we want to do in these agreements. We want to ensure that, hey, if it does happen that way, that we can fix it, because we don't want, when it comes to all of this work, there are a lot of shareholders in a lot of cases. And we don't want to sit here and have to go get all of the consents from all the shareholders yet again, just to do that. Okay. And so I would say that is one way to fix it, one way to cover that on the front end in the event it happens. It's easier, by the way, when it comes to future investors, we experienced this in the past week. It's way easier to say that we amended previous errors. That's why this says amended and restated, or first amended and restated stockholders agreement or something like that. Than it is to say we messed up and knew about it but didn't fix it. Knowing about an error is potentially concealment, right? By a CEO, it's potentially misconduct, right? You just did it with a document. So just remember that. Don't do that. Okay. Be honest and be forthcoming if you do make mistakes. People are way more likely to forgive a mistake that you admit early on than they are to forgive a mistake that you made a year ago and knew about a year ago, right? And last but not least, the last thing I do want to say, and the last thing I do want to talk about, because it is really important. Once you start taking money in the hundreds of thousands and millions, the likelihood of founders, of CEOs, of other C-level executives, and of board members being accused of misconduct and fiduciary duty goes up. That is true. Okay. The reality is, if people see that a multi-million-dollar investment is about to go belly up, or if it's never going to make any money, they're going to see if they can figure out a way, and they're hostile to you. If they're hostile enough to you, they're going to see if it makes sense to sue you. They're going to see if it makes sense to accuse you of misconduct and see if you can admit to something. Okay. And I just want to make sure that you understand that, you can solve a lot of these problems by buying directors and officers insurance, which protects you from accusations of these things so long as you didn't commit them. You can buy larger commercial general liability policies for certain transactions that you're conducting, certain business activity that might come with, potential risk that brings you into higher risk categories. You can ensure that, there's multi-level dispute resolutions internally among, the company and its CEO, CFO, COO, what have you, as well as with the board members, director service agreements, which stipulate how they are to get compensated and what their responsibilities are to be. You just want to make sure that if they have executive authority in that manner, that you are covering all those bases. For directors and officers, you want to make sure you have indemnification agreements. For them, for founders, you want to make sure you have indemnity agreements once you get to the stage, right? The really large seed, a really large Series A, potentially before too. I've seen it for before. I'll tell you, I don't see a lot of indemnity agreements for really early stage or brand new Delaware corporations, though it's common in some cases, because the idea is if we're starting you as a Delaware corporation, we want you to go public at some point. We would hope that you would, right? And then, one other tip I can, say that helps you. Real world example where a popular startup, fired its CEO and there's a lot of drama related to it. Paper up board meetings with official minutes, board decisions with official written consents of the boards and votes. Make sure everyone's taking copious notes of what's happening. Potentially even have the board, have one of the parties or the secretary just record it for posterity's sake. Public companies record their board meetings, right? You can go back and listen to them, okay? And so I would say that, if you wanted to do that, that might help you, and it might actually provide you a defense in the event you actually say, no, we addressed this in a board meeting. They said they didn't want to do this, blah, blah, blah. Like they're claiming I violated the fiduciary duty. Technically, they shot down like this idea that I had, which would have actually, helped the company make a lot of money, or that I brought something to their attention and they dismissed it. They never dealt with it, et cetera. It becomes hard from an evidentiary standpoint if you don't record things in a scrupulous manner. So just go ahead and do that. We don't want you to, we don't want you to get in trouble going forward. But if you're receiving a $1.2 million check, okay, or if you're receiving a $2.5 million Series A or something like that, get that D&O insurance. Protect yourself a little bit further, because you're going to need it at some point. Potentially, at some point, some investor may just hate you for whatever reason, and then that's that, right? Aside from that, I do want y'all to know. Well, actually, let me just pause there for a second. Does anybody have any questions related to this? Is there anything that has come up when I was talking about this that anybody wants to discuss, or do you have any questions in general about startups? Anything that we do that we might be able to help answer for you today? I do have 8 more minutes left on this webinar. One thing to talk about is, if you don't have any questions, just feel free to email me. But if you in reality, when it comes to doing these transactions, you do need to take it extremely seriously. You do need to think it out. I have seen where people dive right in, and these people are like, let's do a deal right now. Okay. People do want to move fast. Okay. Venture capital firms are a lot like investment banks, right? They're trying to they've got the money circled up already, usually, and they're trying to deploy capital. They're trying to ensure that they don't, that they don't suffer, that they don't have to give any money back to their limited partners, that they don't have to do anything, and that they're doing what they're supposed to and hitting the marks that they're supposed to from a revenue standpoint. And so what I would say is just remember that, it's fun. It's a fun space to be in, but don't get so caught up in the deal that you don't sit down and slow it down a little bit. The last term sheet we did took a month. We currently have a client who has been sort of just exploring the options for themselves as far as the term sheet goes. And they've been, I think the patience on their part has actually really helped ensure that they're going to get a better deal. Because, if you're growing fast enough too, be patient. In some cases it's a seller's market, and you can command a higher price. I mean, we effectively negotiated 20% higher on a valuation that was in the tens of millions the other day. And so just remember that, everyone may be arguing that your valuation is too high. The reality is your perspective is always that it's too low, and that your business is going to be, $1 billion success at some point. I mean, some people are realistic and don't think that, but to be honest with you, don't you want that? I don't want to say be greedy, but be cautious about giving away too much equity too early on, because you want to make sure that if this is, a 5 to 10 year business as opposed to a 2 to 4 year business for you from an entry and exit standpoint, as the CEO or the COO or the CFO, that you get in and that you have enough equity to make you happy in the long term. I could continue to talk on and on, but I think I've gone through a ton of stuff here. Do feel free, message me, Kyle@JonesKertz.com. I'll throw it up one last time so that you have my contact info if you want to write it down. That said, if y'all don't, just feel free. Next webinar is going to be first Tuesday of next month, so long as that doesn't overlap with the July 4th weekend to the point where we have to reschedule it. If so, we will actually reschedule that a little bit more in advance so that everybody isn't getting, a rescheduled email every week like we did this month. Unfortunately, this month was an odd month for whatever reason. We just had to do that. It happens from time to time. Anyways, thank you very much, everyone, and look forward to talking to you next month. Take care.